The three adults charged in a break-in at the Woodman Avenue Estates in Ashtabula on January 6, which resulted in a juvenile being shot, appeared in Ashtabula Municipal Court on Thursday, January 15th. Brothers Deandra M. Booker and Quentin Booker, both 25, waived their rights to preliminary hearings before Judge Albert Camplease and had their cases bound over to the county grand jury. Deandra Booker and a 16-year-old male were accused of kicking in the door of a pregnant female. As they ran up the stairs, the woman shot the teen, who is still recovering at a Cleveland hospital. Deandra Booker is charged with aggravated burglary and felony obstruction of justice. It was determined the shooting was justified. Quentin Booker allegedly caused a disturbance at the same location earlier in the day. Police say he is the father of the woman's unborn baby. He is charged with aggravated trespassing and domestic violence. Both men had conditions placed on their possible bonds, including they stay away from the victim and any Ashtabula Metropolitan Housing Authority apartments.
Yes, Your Honor. My understanding is that the defendant will waive his right to a preliminary hearing, and the state would recommend a modification of the bond to $25,000, 10%.
Mr. Shiflett, I have a waiver preliminary hearing form in this file that reports that Mr. Booker's signature on it.
Yes, it is, Your Honor.
Mr. Booker, you understand by signing this document you're authorizing me to transfer the case to Jefferson without any hearing taking place today?
Yes.
That is your signature there on the bottom. Let the record indicate that I'm signing the same document as judge in court and as the person who is attested to your signature. This, I will modify the bond to a $25,000, 10% bond for the state's recommendation. I will transfer the case to the county police court for further proceedings before the county grand jury. The bond is modified as continued. Anything further from the state?
Nothing further, Your Honor.
Anything further, Mr. Shiflett?
Your Honor, only that we would ask the court to consider even a lower bond. I would note that even though there were warrants in the older cases for Mr. Booker, he did move around some.
Your Honor, I did forget to mention, and I apologize, it's probably already a condition, but we would ask that the defendant have no direct or indirect contact with Bria Hawley, and that he not enter upon any AMHA properties, specifically Woodman Avenue Estates.
It will be a condition of bond that we know direct or indirect contact with Bria, spelled the name how?
B-R-E-A, Hawley.
Bria Hawley. To weigh a number of factors. Number one, you're here on a felony. They're two separate felonies. One is a first degree, the other is a third degree, so they're serious felonies. Number two, the fact that you move around is actually a consideration as to why you would be more in the 10% range than the PR range, because you don't have steady residence that you know, from what I've heard, your existence has almost been nomadic during these past recent months. So because these are serious matters, I'm going to keep the bond where it's at. The county police court has the authority to change the bond. It's their case. So that's, I see my job as being to deliver you to them. And then whatever that judge wants to do, that's fine with me. You know, it's their case. They're the ones that make that decision, and they have all of the information available to them to make that decision.
Your Honor, it's the state's understanding that the defendant will waive his right to a preliminary hearing on this matter. In consideration for that waiver, the state has agreed to a modification of bond to a $2,500 cash or surety, together with some additional conditions, which would include ankle monitoring, no contact with the victim, Bria Hawley, directly or indirectly, no entry on AMHA property, specifically Woodman Avenue.
They know that there has been sent to the bench waiver preliminary hearing form that reports that Mr. Booker's signature on. Is that correct?
Yes, sir, that's correct. We have executed the waiver of the preliminary hearing, and we'd ask the court to accept that, as well as the prosecutor's recommendation with regard to bond.
Okay, Mr. Booker, that is your signature, sir?
Yes, sir.
You understand by signing the document you're eliminating the requirement that I actually hold a hearing today?
Yes, sir.
Let the record indicate that I'm signing the document with my name as the Judge of the court, of course, who's attested to your signature. And we'll modify the bond to the $2,500 10% bond, conditions associated with that bond. Matters are bound over to the county police court for further proceedings before the county's grand jury. The bond just modified with its conditions is continued. Anything further from the state?
Nothing for the Your Honor, thank you.
No, that was a $2,500 10% bond, Your Honor?
10%, so that's $250 plus $25. So you get a total of $275.
So I don't need a bail bond, I can just come with $275 to the court?
$275 to the court, yeah. That removes your money. Potentially all that comes back to you minus the 10% fee, which $225 would be returnable, or it could be used for fines and court costs.
Okay.
Good luck.
Thank you, Your Honor.
Police identified Corbin L. Gilliam of West 29th Street as the man who drove the wounded teen to Ashtabula County Medical Center. He is charged with complicity to aggravated burglary, a first-degree felony. His case was continued. He was released after his arrest by posting $25,000 cash bond. But Judge Camplice wondered if he could come up with that much money quickly, why he needs the state to provide legal counsel. Camplice will hold a source of funds hearing as well. Another charge of marijuana possession was also continued. While Deandra Booker was in court, he pleaded guilty to earlier charges of resisting arrest and obstruction of justice from a different case and was fined and given jail time.
My understanding, defense has a motion to make.
Your Honor, we would request a reasonable continuance of this matter. My client, today was the first time that I had met with him. There was an offer which has been made by the state of Ohio, which he would like some time to consider. I would just ask the court grant us a reasonable continuance of this matter so that this young man fully understands his rights.
State.
Well, as indicated, Your Honor, the state is offering a substantial reduction to a first-degree misdemeanor based upon the defendant's level of cooperation in this case. I'm not quite sure what there is to consider, but again, for the record, we would oppose the continuance.
Mr. Douglas, final word.
Your Honor, we think that continuance in this particular matter is reasonable, given the fact that my client does not fully understand his rights. I would like some more time to sit down with him.
Mr. Gilliam, in evaluating the request, understand what my function is. My function is to act as a filter. I hear the evidence. Whatever the state presents, I make a decision on whether or not it sounds reasonable and probable to believe that the offense occurred, number one, that it occurred within my jurisdiction and that you committed it. If I find those three things are reasonable and probable, then I transfer the case. So that's my total involvement. Now, I do have the authority to dismiss the case. If I'm not satisfied that there's evidence, I have authority to amend the case if I feel like a different type of offense may have occurred. So, in terms of what I do as a judge, this type of hearing is a blink of the eye. I do the hearing, it's going to take, I assume, probably 15 minutes, and I'm done with the case, period. I'm also required by law to have this case out of this court within 30 days. So there isn't a big, strong incentive for me to grant continuances in anything relating to a felony. In fact, quite the opposite is true. I just want to hear what it is. People either have the hearing or they waive the hearing. It's really up to them. I don't take a position one way or the other. The state here is offering you something. It's not been identified to me what it is. I note that this is a very serious felony that they charged you with, so I don't know, I don't know what your degree of culpability is. Keep in mind, I don't make a decision on whether you're guilty or not. I just send the case over if there's enough evidence that would warrant review by the grand jury, or I dismiss the case, or I amend the case. I'm going to go ahead and grant the continuance to allow you some time. So I will again set time on this court's docket to hear the case. But I do note that you have publicly appointed counsel in this case. I do note you posted a $25,000 bond, and I do note you posted in fairly quick order. So at the same time that we hold that additional preliminary hearing, I would like to do a source of funds hearing to find out where that money came from for that bond, because you're asking that the state pay for your attorney in this case. So if you have that type of money at your disposal to post that type of bond, then I believe I at least need to, if I'm going to do another hearing, make some initial inquiry into your continuing eligibility for appointed counsel in this case. So I'm going to take a short recess on this matter, take up another matter so you can talk to your attorney concerning this case. I will go ahead and tell you, I'm going to grant the continuance, so that's a given if that's what you'd like to do, but Mr. Douglas can answer any further questions you have concerning the ramifications of what I'm talking about. The bond will be $250, it'll be a personal bond, you did appear in the other case. Anything further than that, Matt?
Nothing further, Judge.
250 and 250.
It's a personal bond, signature bond.
Thank you.
You showed up in the other case, so I'm not concerned about you.